We have a very interesting and informative show for you today. In studio, we have the Honorable Deanne TRIPI, family court judge. We have the Honorable John HICKEY, who is a town judge in the town of Clarence and also a law clerk for a Supreme Court judge. We have Bob Richardson, who is in studio with us today, who is also a law clerk for a Supreme Court judge. And on the phone, we have Michael KRACKER, the Erie County Republican chair. So we're going to talk about the court system in the state of New York. So it's an interesting discussion about what the court system is, how it works in New York. I think you're going to find it very informative. But first of all, I want to introduce these people and give you some of their background. So the Honorable Deanne TRIPI, family court judge. Good morning, Deanne.
Good morning. I'm so happy to be here. Thank you for having me.
So tell everybody a little bit about, first of all, you're a family court judge. I want to get to that, but give us a little bit about your history. So you're obviously an attorney. You have to be an attorney to be a family court judge. So your practice, initially, tell us a little bit about that.
So I was in private practice for 18 years, and after 18 years, I decided to run for Erie County Family Court. In my private practice, I did matrimonial and family law and various other areas of law. But when the opportunity came up, I decided to take a chance and make the run. And so I ran for Erie County Family Court in a contested election, and I was elected to the bench on January 1st of 2014.
So, and you were reelected again. So twice you've been in that race. Twice you've been successful. The first time, like you say, was a contested race. I remember that race well, and you did extremely well. But tell us a little bit about what family court is. Explain what you see day to day. First of all, what's the jurisdiction of family court?
So family court, we preside over all of the families of Erie County. So any town in Erie County, anyone can come to family court.
Right, so the jurisdiction is the full county of Erie.
Correct. And the cases that we hear are really families that come to us in crisis.
Right.
They can file on their own. They can seek an order of protection. They can try to resolve their custody and parenting schedules in our court. We see a lot of emergencies regarding children that are alleged to be abused or neglected. And any child under the age of 18, if they are charged with a crime, that actually happens in Erie County Family Court. They do not go to the county court level.
So in my now 52 years of practicing law, I've always considered family court to be one of the most difficult, if not the most difficult court to preside over, because the issues are so difficult. The issues are continuing in a lot of families. There's a lot of reasons for it, but you have to make decisions about very difficult matters. So, custody is an issue. Two parents fighting for custody, that's always a difficult decision as to where the child is better off. What's the criteria for how you make that kind of a decision?
Well, I will say this. I appreciate that every single decision I make impacts a family. And when it comes to custody, the standard is what is in the best interest of the child,
right.
Taking into consideration
right.
a lot of different factors.
Right.
And those factors can include maybe an untreated mental health issue. It can include an addiction. It can include maybe one parent lives out of the state. So there's a lot of different factors that are taken into consideration. But we really start at two parents come in as equals. That's how it starts.
Yes. And it could change along the way. And it often does change as the child matures, as parents move from one place to another. It often does change, and there are often different issues that come up. Support is part of that decision. So you have to make a decision about support for that child, who's going to be the custodial parent, how the support is going to be divided between the two parents. Those are all decisions that fall to the court when people can't agree, correct?
Yes. So the court, the building itself handles child support. The judges do not. Those issues go before the magistrates.
Okay.
So every issue sort of is separate, unlike the Supreme Court, which you're going to discuss later. But yes, those are all factors to consider is who can best support the child? What is the home life? Where does the parent live? So those are all the factors that we take into consideration, the totality of the circumstances.
So child abuse also falls in front of you. So tell us a little bit about those kind of situations. Those are, again, extremely difficult situations.
Those are some of the most difficult situations because when it's presented to you, it's usually in a crisis situation.
Yes.
It's an emergency. It's
Yes.
because someone was hurt. A child may be in the hospital. There might have been a domestic incident that happened in front of the children. It might be a situation where a parent has potentially overdosed in front of a child. Mm-hmm. So those situations come in as a real emergency.
So, again, it's easy to see how difficult those situations are. And then, again, we get to the area of when a child or someone under the age of 18 commits a crime. It falls in front of family court.
It does. And unlike going to the criminal court, the adult criminal court, their whole matter would be resolved in family court. I hate to use the word prosecuted, but that essentially is what happens. They're charged with a crime. It could be a pet larceny. It could be stealing a vehicle. It could be drug possession. And then they would be considered in our juvenile delinquent court. And that's where services are offered. The whole point of having it in family court is to potentially stop them from becoming part of the adult justice system.
So, there again, I've in my practice, I have a lawyer who works for me that does family court practice for now 42 years. So I spent the first 10 years of my career doing everything, and I was in family court a number of times, and I realized, the difficulty of what that judge is faced with on a regular day-to-day basis in terms of making a decision that serves the family, serves the best interest of the family, serves the best interest of that child. I've seen some very difficult things, and so I applaud you for the fact that you've done it for this long, that, I know how dedicated you are toward trying to make it as reasonable for that family as possible to deal with those issues that are almost very difficult to deal with and almost have no solution sometimes. But that's what that family court is all about.
It is. And, our goal is to somehow resolve the matter so people can leave the court with some stability. It may not be perfect.
Yes.
It's never perfect because no one will have their child 100% of the time unless there's an issue, unless there's a reason to.
Yeah.
But it's never, it's just how to move forward to co-parent peacefully and not put the children in the middle of that.
Now, people can petition themselves into family court, right?
Yes. I often call it the people's court. People can come. It's free to file.
Exactly. So let's talk a few minutes about that. So if there's a domestic situation, if there's an issue between parents, if there's a custodial issue, people can petition themselves to come in front of your court.
Yes. And we always have an emergency part running. And if there's an immediate issue, such as someone seeking an order of protection because of a domestic incident, they can file a family offense petition and see a judge that day. Someone may come in and allege that the other parent has kidnapped the child.
Right.
There could be a situation where a child has been injured and there's a belief that there was abuse in the home. So those would be emergency situations that would see a judge that day.
Wow. All right, let's move on to the Honorable John Hickey. So, John, you are not only a Supreme Court law clerk for the Honorable Paul Witosek, so you see all of that, but you're also a town judge in the town of Clarence. Now, tell us a little bit about your history and getting into being a judicial person.
Good morning. Well, absolutely, and I appreciate the opportunity. And in a few minutes, as I'm listening to Judge TRIPI, I'm realizing what a significant overlap there actually is between family court, justice court, Supreme Court. These are not in a silo.
Right.
And maybe more on that in a minute. I grew up and went to school in Clarence, and when I moved back to Clarence after law school, I immediately got involved in the town. I was in private practice at the time. I started working right away for the law firm that I clerked for here at UB Law 25 years ago, and had a wonderful experience there. And while I was in practice, it was civil litigation defense primarily, a lot of trial work at a young age, which was really wonderful. I started to get involved in some of the community activities, community boards. I served on the Town Environmental Quality Review Board, Seeker Board, eventually the Zoning Board of Appeals. This is all in Clarence. And then I served as the town prosecutor. This is all while in private practice.
Yes.
And this went on for maybe 12 years, all told, at which point an incredible opportunity arose, and Bob Richardson, who is here with us, serves a similar role for a different judge. 12 years ago, I started working for a Supreme Court judge, so I left private practice and entered the courts. And more on that, I suppose, in a moment, too. But the primary, as a confidential law clerk, which serves in a day-to-day role with the courts and with the Supreme Court judge to navigate all types of different issues. And then 7 years ago, one of the two judges in the town of Clarence retired, opening up a vacancy. And it was at that time that after, Judge TRIPI was already judge at the time, had gotten to know her and several other role models, I would say. People who went from private practice into the judiciary, found it satisfying, found it was a new, incredible way to serve their community and to, keep proceeding in their profession. And I was interested and took the opportunity to run, had an incredible experience. It was fascinating, and I've been in that position ever since in the town. So I say this to both Judge TRIPI and Bob all the time. I consider myself extremely blessed to have what I consider to be two of the best jobs in the world as a law clerk and a judge.
So let's talk a little bit about what a justice court judge does. What is your role as the town justice?
Well, Judge TRIPI stole my line. I think the justice court is also the people's court. And in a lot of ways, I say that because it's oftentimes the only exposure a citizen or community member will ever have to court. The town and village courts, there might be 11 or 1,200 such judges throughout the state. It is a big state. Handle everything from traffic tickets, vehicle and traffic law violations, and you could picture those, whether it be speeding or cell phone and the like. You handle town ordinance issues, whatever those might be. Every town, village, city has its own ordinances.
Town code violations.
You got it. Handle those. Those are handled by a town prosecutor, a role I used to fill. Different from the criminal matters, which the town and village courts also handle. That's where you have a district attorney, assistant district attorney come out as opposed from the town prosecutor, and you handle all levels, at least preliminarily, of criminal cases.
So it starts off, if a crime is committed in your town, the arraignment starts off in your court. Isn't that correct?
Yes, absolutely. So an arraignment for all levels of crimes is the defendant's opportunity to know as soon as possible what charge or charges he or she is facing. And then immediately after that, that's where the court, in addition to presiding over everything, makes sure that defendant and counsel know exactly what their rights are from that very preliminary stage. And so that's called the arraignment. And yes, regardless of if it's a petty larceny, all the way up to homicide.
That's right. So it doesn't matter. We typically look at justice courts as misdemeanor courts, but the initiation of any criminal matter that occurs in that jurisdiction, in that town, is handled by that court. And not only the arraignment, but if in fact it's a felony, then the defendant's entitled to a felony hearing. And so that you preside over also, correct?
Absolutely. And you're right, it is the initiation court for all levels. Misdemeanor court is fair if you want to play it out to the end. That's the maximum level of sentence that at the back end of a case a justice court could potentially preside over. A defendant charged with a felony does have significant rights that could present themselves if come in the local court. You're absolutely right. A felony hearing must be conducted within a certain amount of days after custody.
Which gives that judge a great deal of experience in all of these different matters. As I said, we have a very informative show for you today. We're talking about the court system in the state of New York. We have in studio the Honorable Deanne TRIPI, the Honorable John Hickey, and the no less Honorable Bob Richardson. And on the phone, we have Mike KRACKER, who is the chairman of the Republican Party here in Erie County. So we're talking with John Hickey about his role as Clarence Town Judge, a role that you've had now for how long, John?
I'm in my 7th year.
7th year.
Yep.
And again, so it is typically thought of, at least lawyers think of it, as a misdemeanor court. So you hear to a conclusion anything that is charged as a misdemeanor from your town, correct?
Yeah, that's right. And yes, when you have practitioners and people in the criminal justice system who are dealing with high-level felonies where state prison is contemplated, you hear misdemeanor court and you might infer something. I learned right off the bat, after coming from a world of mostly civil litigation, that there are no small criminal cases. I mean, you're talking about liberty. A misdemeanor is every bit as much somebody's liberty as a felony is, whether it's a weekend in jail or something in state prison. So, it's important that there's a real dignity and respect that is paid to each and every case. To answer your question a little more directly, yes, if a matter is going to stay in felony posture for one reason or another,
it moves from your court to a higher court.
Correct. We divest, which means you no longer have jurisdiction. It goes to the superior courts, which we'll talk about in a little bit, and that's county and Supreme Court. If it stays, that means that one or a couple things have happened, but it's going to be misdemeanor, whether the charge was reduced by the people or what have you. In the state of New York, the top misdemeanor is an A misdemeanor, and the maximum sentence for an A misdemeanor is a year less a day. So that's the biggest exposure ultimately that a defendant would have in justice court.
But that's still a lot of burden on the judge. You have to make a decision, even in a misdemeanor case that you'll hear to the end. So you oftentimes have to have a trial. People are entitled to a trial on the misdemeanor charge. You have to make the decision as to whether or not that individual is guilty, hearing all of the evidence. And even if that isn't the case, even if there's a plea situation, you still have to make a judgment call as to what the penalty should be. And I presume in your 7 years you've put people in jail. I presume you've given conditional discharges. I presume you've run the gamut.
Each case is absolutely different and stands on its own. Misdemeanor or felony, the criminal procedure law, the rules of evidence, the United States Constitution, the New York State Constitution apply equally regardless of the charge. I'm always mindful of that as well. What Justice Court does allow one to do, though, you're right, there is a repetition and a level of experience because of the diverse nature of these cases that puts you in a position where, case by case, you are in a position to analyze whatever facts are before you, know the law as time goes on, apply it to the best of your ability in that moment. Ensure, I'm always mindful of this. I always have this somewhere in the back of my head because it's so important, although basic, is that everyone, all sides, are entitled to due process. And my application of those rights, while mindful of the unique facts and circumstances of each case. And to answer your question even more directly, yes. If you get to the point in a case where there is a guilty verdict, whether it be by virtue of a jury, a bench trial, or a plea, those are all different types of convictions, but convictions nonetheless, where you then move into the sentencing phase. Sentencing phase can include jail time. Yes. It can include monetary, everything from, to your point, an unconditional discharge all the way up to jail time. And you're absolutely right. The judge at any level, including the local court, like myself, is tasked with learning as much then at that phase about the defendant, his or her life, their experiences, the case before you. And probation, in certain cases, will write a report. It's called a preliminary sentence investigation that will further inform the court to help in that sentencing phase.
One last thing I want to talk about with you is the orders of protection. So when there is an abuse situation in your jurisdiction, the town of Clarence for you, oftentimes someone will come to you and ask for an order of protection. Can you explain what that is and what the considerations are?
Sure, and this is where Judge TRIPI's family court experience and overlaps to a certain extent with local courts. And I should say, Judge TRIPI and many of her colleagues do a wonderful job of training Justice Court personnel in these matters, because they in their courts see these things
All the time,
and they play out, and they're daily. So yes, in local court, the order of protection, it can present itself at any number of different times in a case, but it's very typical in the local court that whatever situation arises will reveal itself with some charges. So a defendant is brought in for that arraignment we talked about a few moments ago, and if the hypothetical case has an allegation of something that would potentially put, we'll call them the protected party or the complainant, or the person alleging, being a victim in a particular case, they might seek an order of protection. At the local court, that's my opportunity to gather as many facts on a very short period of time, to ensure those due process rights are protected for everybody, but also to recognize the potential volatile situation, at least in a 12 or 24 or 48 hour period, where an order needs to be put in place that is further is a further way to maintain everyone's health, safety, and well-being in a short period of time until they can make their way to family court or Supreme Court.
All right, so now I want to move to Bob Richardson. So Bob, again, give me your background, your legal experience, and then we'll get into your role as a law clerk, which is a substantial role as far as I'm concerned.
Yeah. Thank you, and good morning, Ralph, and good morning to all of your listeners. Thank you so much for having me here today. I did kind of want to start by saying this is a wonderful conversation. The judiciary is such a crucial and vital role
It certainly
in
is.
American society, and it's something that doesn't get talked about very often. So I think it's wonderful that we can be here today to talk to your listeners about a co-equal branch of government that has such an impact. But as far as my upbringing goes, born and raised in the town of Tonawanda, which is actually kind of where my legal interest started, because I was heavily involved in my town's youth court. And I actually helped start it.
An excellent. I was part in 1984. I established youth court in the town of West Seneca. I was part of what established it. What a great program!
It's a wonderful program, and I helped start one in Grand Island when I was there as well. It's kind of almost where my roots come from my love of the law. So after I graduated high school, I went to Colgate University and got a degree in mathematics, if you can believe that.
Wow.
I went to UB Law after that. When I got my law degree from there, I started in the Erie County District Attorney's Office, where I started in Buffalo City Court, dealing with misdemeanors and felony hearings and those things that were previously mentioned. From there, I went to the Justice Courts, the town courts, places where Judge Hickey hangs out. And from there, I went to prosecute special investigations involving drugs and juvenile crime. Until I was, incredibly honored to have been selected by Supreme Court Justice Frank Caruso to be his law clerk, where I've been there for the last 20 years.
So, look, I can't say enough about how great your judge is. I mean, I know Frank Caruso for all of those 20 years and beyond. An excellent jurist, but more importantly, an excellent person who really feels for people that are in front of him. But I realize that the job of being a judicial law clerk, a lot of it falls on you.
I mean, certainly, Justice Caruso, he leads the ship. He's the captain.
Sure, I get it.
A law clerk kind of almost has the role of, first mate. For sure, I deal with a lot of, pretty much everything that comes through the door in our chambers hits my desk first.
Right.
And then, I kind of figure out where it needs to go, what needs to happen with it. I'll talk to Justice Caruso about what we need to do with it. But we handle so many different things,
right.
So it's almost impossible for Justice Caruso himself to deal with every single thing. So it's important to have a chambers that kind of manages the workflow. I think we do a good job of that.
So one of the things I do want to talk about is jurisdiction. So the way it works is in a justice court, John, what's the monetary jurisdiction?
Oh, from a monetary perspective, the only time the Justice Court is really involved with civil matters, we'll say, you commonly know them as small claims. So if that's what you were referring to,
well, you could have a civil lawsuit in the town court. I mean, I could sue somebody for the jurisdictional limits in the town court, a full civil lawsuit.
Yeah. It's typically a
$3,000 limit
threshold. So it's you'll hear from Bob and Judge Trippi that by comparison it's lower, and I believe the city courts have maybe a $5,000.
The $3,000 limit, that was initially what the limit was when it was established, and it's never changed. It needs to be changed as far as I'm concerned, but you have a jurisdictional limit of $3,000. City courts have a jurisdictional limit of how much?
I believe it's $10,000.
I think it's $15,000 for Buffalo City or for Lackawanna City Court.
Okay.
So they have also a physical jurisdictional limit. So you have to either reside in the city or a suburb contiguous to the city. So, for example, if you have a $15,000 lawsuit claim and you live in the town of Orchard Park, which is not contiguous to either the city of Buffalo or Lackawanna, where do you go?
In that case, I think you'd probably come to us in Supreme Court.
In Supreme Court.
Yeah.
So there are these what we call jurisdictional limitations to these different courts, but Supreme Court has no jurisdictional limitation, correct?
That's correct. You can bring anything in Supreme Court. It's a court of general jurisdiction in New York State. Pretty much any type of law, you can come to Supreme Court and start your case there.
So we call it the Supreme Court in the state of New York, but it's not the top court of the state of New York, correct?
That's correct. Unlike the federal model where the Supreme Court is the highest court in the land, in the state of New York, it's kind of reversed. Supreme Court is the trial level court. It's the court that's closest to the people. It's where you start. And then there's various appellate courts from there. You go up next to the appellate division. There's 4 different departments in New York State to handle that. And then from there, you might go to the Court of Appeals to be the final highest court in New York State.
So the general jurisdiction is the Supreme Court. So in order to be there in Supreme Court, there's no monetary limit. You any amount. It could be, any amount, and you can go into Supreme Court. In terms of its physical jurisdiction, a plaintiff or a defendant has to reside in the district, which is an 8-county-wide district, correct?
Correct. It's the case is brought by filing a summons or complaint, usually in the county upon which one of those two reside in, unless there's been an agreement or a contract that selects a particular forum. So in Supreme Court, the judges in Supreme Court in the Western New York area are elected from the 8th Judicial District,
right,
which comprises the 8 counties of Western New York. But each justice is typically assigned to a particular county. So, for instance, Justice Caruso is assigned to Niagara County. So our office is up in Niagara Falls. So we handle Niagara County cases, but he's also been assigned the justice in Orleans County.
Right. So
we handle Orleans County cases as well. So they're typically kind of divided by county, but the justices themselves are from the 8th Judicial District.
So, again, as yours and John's role, because John is a law clerk for Honorable Paul Watasek, another extremely good judge who's done an excellent job. So your role as the law clerk spans a great deal of what a judge actually does. I mean, you do day-to-day pretty much the exact same thing as the judge does, only you don't get the final say.
That's pretty much true. I've pretty much been involved in almost every aspect of what happens in Supreme Court, with the exception of actually being on the bench for a jury trial. I talk to attorneys, I conference cases, I talk to self-represented litigants, I review motions. Pretty much, like I said, everything that comes through the door is going to hit my desk first. obviously, Justice Caruso has the final say, and, we worked very closely together.
We're here in studio with the Honorable Deanne TRIPI, the Honorable John Hickey, and the Honorable Bob Richardson, and we have Michael KRACKER, our Republican County Chair, on the phone with us. Mike, we've been talking to the judges. I want to get you involved in this conversation. Do you have something to ask any one of our, the judges that are here, or the judge law clerk?
Well, first, it's an honor to be joined on this esteemed panel of attorneys and judges, and my best to all of you. And this has been an informative discussion. I guess what I would ask for each of the three judges and clerks that are with you today is what motivates somebody who's an attorney to want to pursue serving on the bench. Obviously, the three of you are pursuing a state Supreme Court position. Judge TRIPI spoke about her campaign for family court. Judge Hickey in Clarencetown as Clarencetown Justice. What is it about serving on the bench that appeals to the three of you?
Before I let them answer, let me just tell you this. As an attorney, if you want to reach the top limit of what you can do as a lawyer, it is to become a judge. And I think almost every attorney has at least that in the back of their mind at some point in time, that, I can serve people better. I can serve the public interest if I can become a judge. So go ahead, Deanne, what do you feel?
Well, I will say that in private practice, it was never actually my goal or thought to take the bench. People talked about it, but when the opportunity came, I thought, I have 18 years of experience that I could share. I represented moms, dads, and kids. I've been on all sides of the case. I really believed that I could take the bench, be prepared on the first day, and be fair to the families, understand all the sides, which is really important. And so that's why I pursued it. And that's why this is a great state. And our justice system is great because people like me, a lawyer, can actually become a judge.
Your motivation, John?
It's similar with my own path, which is I didn't have this at the outset, that is for sure. I really enjoyed working in private practice for a variety of different reasons. I ended up working for this incredible man and mentor that you referenced, Judge Paul Watasik, where we had a full civil, like Bob Richardson. I do want to add that when I started out as a law clerk, Bob had already been serving in that role for maybe 5 or 6 years, and I relied on him heavily because we were now thrown into this general jurisdiction where we were given matrimonials.
Everything, right.
And I would often call Bob and say, listen, can you? And he was always there to help me, as was Judge Caruso. Private practice, civil was my experience. We spent a couple of years in Chautauqua County. I got to know more lawyers, more communities. Then we started doing criminal work in Supreme Court, where I realized, quite honestly, like Judge TRIPI, well, here I am now after 15 or 20 years. I've got this building series of relationships, not to mention experience with almost all matters of law. I'm finding a real enjoyment and satisfaction, and it seemed like a progression that I'd really, really be interested in based on all of that. So while I certainly didn't have that thought at the outset, you can see as a career sort of makes its way through the decades that sometimes the next opportunity to serve not only local but the bigger community can present itself, and I've been very blessed that some of these opportunities have come along.
Again, I don't think coming out of law school, we come out of law school thinking we're going to be a judge, but I think as you progress in your practice, especially as Deanne said, once you have a number of years in, 18 years she had in. You need to have a minimum of 10 to be running for Supreme Court. But as you progress into that, I can, I see, or at least I think from my perspective, that it is something that you admire to be the judge. I mean, I was actually asked in 1993 to run for Supreme Court. I did run for Supreme Court in 1993. It was a great experience. I did not win that race. I lost. I'm happy with where I am at this point in time. But I just, think that that's part of it. So, Bob, what about you? I mean, you've been so close to that role. I mean, you're right there in court every day. You've been doing it now for how many years?
This is our 20th year.
20th year in front of a fabulous judge, Frank Caruso. I mean, I can't say enough for how great he is. But I know what the judge's law clerk does. And you are involved in every aspect of almost every single case.
Yes. Yeah, and for me, that certainly factors into it. I've had a very close relationship with Justice Caruso. I make a lot of recommendations to him, and I've been fortunate in that he, agrees with a lot of my analysis and will, usually make the decision that I've recommended he do. And I think I've reached a point where I'm helping to make these decisions. But at the end of the day, it's Justice Caruso who has to take the hit.
He makes the final decision.
Right.
I get it.
So, at this point, I'm kind of ready to take the mantle of responsibility, if it were, and to be held accountable for, the ways that I analyze cases and the recommendations that I make as well. And there's a certain aspect of, I've always been drawn to public service. Like I said, I was involved in youth court in Tonawanda from a young age, came up there. I've been involved in community, groups and organizations throughout my whole life. So I've always really wanted to serve, and, the progression, as you mentioned, Supreme Court Justice is an outstanding way to serve the people of New York in my community.
So look, now that I've been practicing 52 years and know each of you practically from the beginning and know you very well, I admire you greatly for what you are able to accomplish. I know that at this juncture, you're all potentially candidates for Supreme Court. Certainly, you have the capability. Certainly, you have the background. Certainly, you have the temperament, I believe, to get there. The role that you each play is such an important role in our community, the role that you play at this present time. So I just think it's fantastic that we're able to be here. Now, normally, a judge can't involve themselves in politics. Isn't that the case, Judge Deanne?
Yes. We are one of the three tiers of the system. So there's the judiciary, the executive branch, and then there's the lawmakers, the Congress. And we're the tier that has to remain neutral, and whatever laws are put in place, we follow those laws. We cannot take a position on any law that's proposed or take a position against a law that's in effect. We are just supposed to know the law, apply the law.
But again, you take yourself out of the political realm once you're appointed as a judge. So you in family court have taken yourself out of the realm, you in Clarence Town Court. Now, the reason you can get involved, the two of you that are judges at this point, is if you put in a letter that you're seeking another judicial position, then you can seek that position. Isn't that the position you're in today, the two of you?
Yes. In order to get back out into the political arena, you do have to send in a letter to your presiding justice indicating that you are now running for a position. And that lets you go back out and go to political events and fundraisers and be actively involved so you can get support on the race that you're running.
So our system is geared to protect the court system itself so that you are impartial. We don't talk about, as you said, Judge, we don't talk about how you would make a decision on any type of case. That's because it's all fact specific. You have to take into account what you believe that's in front of you, what's been presented that's in front of you. So we don't get into that. We don't talk about that. We, essentially talk about your character, all three of you, about the character, about your experience, about your background. Those are, to me, the important things about someone wanting to attain the position of a jurist in this state. Mike, how do you feel about all of this? You and I are in the position of helping people who want to achieve this goal. You have a greater role than the Conservative Party. You have a major role in how this is handled. So tell me your thoughts about it.
Well, Chairman, I think you and I have worked very well together in this regard, and I think you and I would both agree that we look for individuals who are highly qualified and who will conduct themselves on the bench in an ethical and honorable manner. And I think what you've heard from these three individuals is just that. Three individuals who take their work seriously, whether it's on the bench or assisting their judges as clerks. And that is important. It's a very critical role to have qualified and quality individuals serving in our judicial system. And as party leaders, I think we make sure and make a sincere effort to elevate individuals who meet that standard. So obviously we're entering a Supreme Court election year, and that is going to be a big determining factor in how we select our candidates, who then will go and make their case to the voters of the 8th Judicial District.
So I want to cut our three people here loose for a second, and you and I talk about the political aspect of what's happening now in New York. So there's been a new bill that's been passed by the legislature, has not been signed by the governor at this point in time. The bill was passed last year. She did not sign the bill. But that bill would make Erie County its own judicial district. So right now, Erie County is one of the 8 counties that make up the judicial district here. What happens in your mind when that changes?
Well, Judge TRIPI, we've talked about the fact that the judiciary is supposed to be independent of politics, and unfortunately, the state legislature is attempting to inject partisan politics by effectively gerrymandering our election districts. The 8th Judicial District, the 8 counties in Western New York, has existed as a judicial district, and I think has been successful in electing a great balance to the state Supreme Court. This would effectively shift that balance heavily to the left by making Erie County its own judicial district. Erie County, of course, nearly 2-to-1 Democrat by enrollment. And the clear intent of this legislation is to shift the balance of power in our judiciary towards the Democratic Party and left-wing ideology. So I think it's a very damaging bill. It's been criticized by members of both parties. The governor vetoed a similar bill last session. That's certainly my hope that she would do so again, to make a statement that she believes that the judiciary should be separate from partisan politics, which this judicial gerrymander seeks to inject into our state Supreme Court system.
Well, I certainly feel exactly the same way. I think we have a great balance in the eight counties that make up the judicial district. I would hope that she understands that and that it continues in that fashion. Look, I want to thank everybody for being here today. This was a great, not only a great discussion about the court system, but a very informative discussion for people. We have great people here today. I appreciate, Mike, that you joined us today.